Good evening and welcome to Left, Right and Centre. I'm Nidhi Razdan. On the programme tonight, the shocker of a judgment from the Supreme Court which says gay sex is illegal. Is the court verdict a violation of human rights? And by passing the buck to Parliament, has the top court let down India on a basic question of fundamental rights? Over the next 60 minutes, we look at different aspects of this important judgment, one which many say takes India back to medieval times. Well, the country has reacted with shock today to the Supreme Court's verdict that has criminalized homosexuality all over again, more than 4 years after a historic verdict by the Delhi High Court that had struck down the regressive and archaic law known as Section 377. Today, the Supreme Court has said it is now for Parliament to change the law. In the order, Justice G.S. Singhvi and S.J. Mukhopadhyay have said that the High Court overlooked that a minuscule fraction of the country's population constitute lesbians, gays, bisexuals or transgenders. That in the last more than 150 years, less than 200 persons have been prosecuted. In its anxiety to protect the so-called rights of LGBT persons and to declare Section 377 as violating the right to privacy, autonomy and dignity, the High Court has extensively relied on judgments of other jurisdictions. The Supreme Court goes on to say abuse of power given by law does occur, but that the validity of the law cannot be contested because of such an apprehension.
50 million Indians, peace-loving Indians, who yesterday were not criminals and today are criminals.
These people are forced to go underground and they have no access to medical care.
Nobody's looking at that it's a huge setback.
The Supreme Court has actually undone it and thereby setting the clock back.
Affects your morale as to who you are and, do you have the confidence to come out and be who you are?
I think it's an imposition of a medieval mindset.
Shock, disbelief and heartbreak across the country as the gay community, rights activists and even some legal experts questioned the Supreme Court when it set aside the 2009 landmark judgment of the Delhi High Court which had decriminalized homosexuality. Today, the Supreme Court reversed the order, which means gay sex, even between consenting adults, will continue to be a criminal offence that can invite a life in jail. The court has ruled that the Delhi High Court verdict is constitutionally unsustainable and there is no constitutional infirmity in Section 377 and that it is now up to the government to take appropriate legislative steps to scrap 377. Those who have waged a long and difficult legal battle seeking equal rights for the gay community say the Supreme Court verdict has set them back by decades, while others did not agree with the court lobbing the ball into the government's court.
Why only when it comes to human rights do they defer to Parliament?
Who should I go to ask if a criminal law as part of the Indian Penal Code violates my fundamental rights?
For those who had petitioned against the Delhi High Court order, it was a welcome decision.
समलैंगिकता एक अनैतिक, अमानवीय, असंवैधानिक कृत्य है. मैं इसको गलत लत कहता हूं.
Legally, this means that there is no fundamental right in sexuality as far as I feel. And what the Supreme Court says that no fundamental right has been violated. But what they're talking about, they have set aside the High Court judgment.
Legally, the way ahead for the LGBT community is to file a review petition, and if that too is turned down, the last option would be a curative petition.
The LGBT community says they're heartbroken but not ready to give up. They say they'll file a review petition in the Supreme Court, take their fight to the streets and try and build pressure on the government. But having done a series of flip-flops on the issue and now being described as a lame duck government, will the centre have the political will to legislate on such a sensitive issue? With Siddharth Pandey in New Delhi, Neha Khanna for NDTV.
So has the Supreme Court's verdict today been a fundamental violation of human rights? That's what we're talking about on the programme tonight. Joining us this evening, the Additional Solicitor General, Ms. Indra Jai Singh. Here in the studio with us, Shohini Ghosh, prominent gay rights activist and professor. Zafaryab Jalani of the All India Muslim Personal Law Board, joins us tonight from Lucknow, which was one of the petitioners that had argued against the Delhi High Court verdict in the Supreme Court and wanted it to be upheld. They wanted Section 377 to be upheld, and that's what they've got today. And we also have senior lawyer Majid Memon joining us tonight from Mumbai. We'll be joined by Dr. Abhishek Singhvi of the Congress Party shortly. But Ms. Jai Singh, let me ask you first, ma'am, on one or two of the key points that we have picked up from the judgment. One, the judges say that the High Court overlooked that a minuscule fraction of the country's population constitute lesbians, gays, bisexuals and transgenders, and only 200 people, they say, have been prosecuted in more than 150 years. They also talk about the so-called rights of LGBT persons and also say that while there is abuse of power given by law, the validity of that law cannot be contested because of apprehension that there will be an abuse. What are your first reactions to that, ma'am?
I think there's a fundamental misunderstanding of the role of the court, if I may say so. The whole purpose of having a court, and a Supreme Court at that, is to protect the rights of minorities, no matter how minuscule, quote unquote, they may be. You know, when it comes to Parliament, you can understand voting on the basis of numbers. There will be votes in favor, there will be votes against, and the majority view will prevail. But Supreme Courts are not expected to uphold majority views. Supreme Courts are expected to decide on the basis of fundamental understanding of the right to life, regardless of whether that concerns a minuscule minority or even, for that matter, one person. 200 people being prosecuted in 150 years, well, it's the tip of the iceberg. I think the Supreme Court should understand there are a whole lot of others who are harassed by the police, who are driven out of public places, who are maybe picked up and tortured. Maybe prosecutions don't go through because, you know, the police can be bribed to drop prosecutions. We don't know. Anyway, this is not a number game. And I would say that if a law violates even the rights of one person, if it does, it has to be declared unconstitutional.
Did it come as a particular shock to you because of the fact that we've seen judicial activism in so many other spheres in the last few years? We've seen the court, overturning laws, changing laws, and intervening on a range of issues. And here, they have said that, well, it is for Parliament to change the law. Did that add to the surprise?
Well, I mean, I must say that an observer of the court for the last 4.5 years, 5 years, I've seen not only the court, but the judge who wrote the judgment, who incidentally retired today, intervene in a whole range of issues that concern all of us. Any number of judgments, the last of them being delivered yesterday on the question of why Lal Battis should not be given to everybody except 5 constitutional functionaries. So it comes as a surprise from this particular judge that the only basis for upholding this judgment is the doctrine of judicial restraint. But I must tell you, there are so many ironies in this judgment. The judge quotes Justice Kirby, and I wonder whether he knows that Justice Kirby himself is gay and has been in a long-standing relationship which has gone on for more than 20-25 years. I think we need to open our eyes and see what's going on in this world and keep pace with the times.
All right, very important words spoken there by Indra Jay Singh. Shohini, the thing that is at the heart of this judgment today, which many people don't understand, is that this is not just about gay people. This is about everybody. This is about the court and the state saying that we have a right to interfere and intervene in what goes on in your bedroom between consenting adults. And that is something that should scare everybody.
Yes, you're absolutely right. This law, the overturning of the 2009 judgment will directly affect the LGBT community. But at the same time, I must say that the LGBT community has lived with 377, for years on end, except for the last, few years. So they will survive this. They're not going to be defeated by this. But it will certainly make them more vulnerable. We have seen in the courts today and on television studios kind of the language that is being used to describe, gay, lesbian people. This is something that people would not have done, had the 2009 judgment, been upheld. But I think it's really important to understand that one, it is not just the gay lesbian community that is affected even by 377, because 377 actually outlaws any kind of sexual activity that is not vaginal, and that is something that is not particular to the LGBT community. It is for everybody. So this is something that directly concerns everybody. But at the same time, the very fact that we talk about 377 in connection with the homosexual community or the LGBT community shows that this law is primarily used against this community. And this is precisely what the 2009 judgment said. That if you have this kind of prejudice against these people, it doesn't let you be a full citizen, that it is violative of the fundamental rights. So I think that more than ever now, it is important to go back and see what were the arguments of the 2009 judgment. And I think that, it upheld some of the best ideas in the Constitution of India. So even though this one particular judgment might say that we have set it aside, but actually we have to keep returning to it and see what it says, because I think what it says has more significance today than ever before.
And so you do see today's order then as a violation of basic human rights?
I see it as a complete violation of human rights. I see it as violative of the fundamental rights of people. It is a judgment that is telling a whole lot of us that you are not full citizens. And it is completely outrageous.
Let me take this to Dr. Abhishek Singhvi, because Dr. Singhvi, one of the things that the judges have said in the judgment is that their conclusion is further strengthened by the fact that despite the decision of the Union of India not to challenge in appeal the order of the Delhi High Court, Parliament has not made any amendment in the law. So they've used that as a justification for going ahead with their verdict. Is there really a political will, Dr. Singhvi? Let's be honest here. Would Parliament, firstly, Parliament isn't functioning, but even if it was, do you really think that this would actually get through Parliament?
Nidhi, I'll be happy if you permit me my 1 minute, because I'm going to give a very nuanced answer.
Sure.
And I want it to be very clear and not misunderstood. First of all, I am not speaking in the capacity of a member of Parliament or a Congress spokesperson, because this is not a political matter, it's a matter of a judgment of a court. Secondly, I personally believe, it's my clear personal view, that 377 must go, has to go, shall go, and it is a very bad scourge on our statute book. My personal view is that this kind of thing should not be criminalized. However, and that's the nuance to the answer, having said that, I for myself, speaking as a lawyer, would agree with the reasoning of the judgment that it is something for Parliament to do. Fourth point, Nidhi, the fact that Parliament does not have time, does not do it, or for a variety of reasons it gets aborted or obstructed in Parliament, cannot be a reason for judges to make pure law, because they would be purely making law by virtually repealing a provision. Having said all that, I also must add that I must applaud to this limited extent the fact that the judges showed the courage to stand up to what they felt was the right view of law, even though they knew that the popular feeling was otherwise, even though they knew that there would be media bashing of the judges if they held otherwise. And I think therefore to that extent it is a victory of law to some extent. Although I vehemently disagree with the merits, I do think this should go. But the judges may not be wrong in saying that this cannot go like this. It has to go through parliamentary repeal or parliamentary modification.
The same Supreme Court has intervened on a range of issues, whether it is disqualifying MPs who have criminal charges against them. That is now law today. We see that has been historic. We've seen MPs actually being disqualified. We've had the Lal Batti order yesterday. This is a question of basic human rights. This is a question of fundamental rights. You don't think here that the Supreme Court, even if it was throwing it back to Parliament, should have at the very least had some strong observations on what Section 377 is?
Look, Nidhi, I can agree with you partly, but that's where the nuance lies. What they could have done, there are value judgments on both sides. Certainly they could have done what you are saying. But my question is a little different. Can it be legally wrong and castigated for not having done two equally permissible courses of action? Were they obliged to do only one action? No, the answer in law has to be no. Because this was in a sense largely a policy decision which ideally the Parliament should have taken. You please understand the nuance, Nidhi. I myself believe it should go. But the judges say we are not the ones to take it off. Parliament should take responsibility for it.
Okay.
And I think that's correct in law.
Okay, Indra Jaisingh, is that correct in law, technically correct in law, or you believe strongly that the court needed to rise above that yet again when it has done so in the past?
Yes, I think as Abhishek points out, where two views are possible, the court decides to take one view, and then he goes on to say the court cannot be faulted for that. My point is that precisely where two views are possible, what decides which way you're going to cast the die is what you think in your mind and what your values are. That's what makes the critical difference. And in that sense, I do not think this judgment is as neutral as it appears to be, namely just a judgment which says that we need to exercise judicial restraint. Given the fact that there was a well-argued, well-decided judgment of the High Court, if the judges wanted to differ with it, I think the better thing for them to do would have been to say, let us refer this to a bench of 5 judges, so that you have a diversity of opinion reflected over here. And at the end of the day, it did involve issues of the interpretation of the Constitution of India, that is the right to life. Abhishek, though he says he's not talking as a politician, I think he's coming across to me as a politician.